Okay. That sounds with a little bit of enthusiasm. A little, not much, little. Okay, so let's start. It's a nice sunny day, and y'all should be ready to work. Brains percolating to the top capacity, correct? Oh, silence again. Silence again. I don't know why. Okay, so we're gonna do type of accounts today. We did the money laundering last week in anticipation that all of you would have taken the exam, but as usual, you all decided else otherwise. So let's start. Someone else coming in. Okay.
Which page this is, Miss Archer?
This would be page 52 on my own.
Thank you.
Have it?
Yes, ma'am.
Okay. All right. So we're going to talk about type of customers, meaning type of accounts. So we know that the customer banker relationship follows the process under contract law in terms of the elements. So the standard formalities are required to open an account for a customer. And that includes the bank opening documentation, the ID requirements, specimen signature. If there's a joint account, of course, signature of both persons. Then you would have to advise them of the contractual nature and the terms of the account. That is the duties, the rights and the obligation, the rates and the fees. And I don't think you all do that part. Advising the customers of all the due diligence and account operational requirements. And of course, getting the amount that's required to open the account, getting the account number, and then providing the debit card. And depends on the type of account, you will get the little booklet that surrounds the operations of the account. So let's start with the first type of account, which is an individual account, which I guess all of you are familiar with. You know, only thing that's required is the identification. And normally you would state what the purpose of the account is for. And that's about it. It followed the normal process, the steps we said before. But then you have a power of an attorney. So when you have a power of attorney, that means that that's an individual that's acting on behalf of another, or it could be an individual who acts on behalf of a company. The power of attorney can be general or it can be limited, which means only for a specific purpose. So when you sign a power of attorney, you can use either the legal one that's done by an attorney or the bank themselves have a power of attorney form that can be completed. So once you sign the power of attorney form by the bank, what you do is you actually agree to the powers that are actually stated in the bank's mandated form for power of attorney. And an agent can only act within its authority. So when it acts on behalf of his or her own benefit, then of course it's fraudulent and they are personally liable. And of course, the bank can also be liable if it's found that the bank is a constructive trustee of the funds received by the agent unlawfully. Which means that the agent was acting on behalf of the account, took off funds, and then deposited those funds in their own account. And that's when the bank becomes what you call a constructive trustee by law. And the bank then becomes liable. So a power of attorney is a formal legal document signed by one person, authorizing another person to act for their benefit in carrying out certain responsibilities. The principal is bound by all the acts performed by the agent in the execution of their duties. So the agent would have represented and contracted or transacted with the individual under the agency agreement. and the agency itself is terminated if the power of attorney is revoked, either by notice by the agent or the principal, by the mental incapacity of the principal or the agent, or the whatever the purpose for the power of attorney was actually drawn up for, whatever the arrangement was. Once that is fulfilled or completed, then the power of attorney is revoked or terminated. Or you could have the power of attorney has a time period on it. The time period may have expired. The principal or the agent may have died. The agency itself, the arrangement may be frustrated, or it could be due to illegality or insolvency of the principal. So an individual's account holders is terminated upon notice by the bank of his death, mental incapacity, or upon reasonable notice by the bank to terminate the banker-customer contract. And you know, in the case of Maurice Clinton versus Scotiabank, they discussed what is called reasonable notice. In terms of Scotiabank not giving Mr. Clinton reasonable notice to close his account. So under the law of agency, an agent who exceeds his authority is personally liable to a third party. The bank may be liable to the principal if proper inquiries were not made by the bank staff to ascertain the agent's authority. So if you are in doubt as to whether or not an agent can carry out a particular task and the power of attorney doesn't explicitly state it, you're not sure, the onus is on the bank to make the proper inquiries to ensure that the agent has the authority to carry out the act for which he intends to pursue. So when an agent creates an overdraft without authority, again, that agent will be personally liable for the debt. And it won't be the principal, it'll be the agent. I gave you all a copy of the handout on agency. Did anyone read it?
Good night.
Good night. Who read the handout on agency? I hearing nothing. Absolute quiet. Okay, so before we do joint accounts, let's look at agency. Because when you speak about individual accounts, you may have an agency agreement where an individual gives someone else a power of attorney over their account. You also can have an agency arrangement when you have company accounts. But let's see what agency is all about. So an agent is merely a tool that is used by a principal to negotiate a contract. That agent is not a party to the contract. The principal, however, is a party, and although he may not have played any part in making the actual arrangement for the contract, all the usual rules as to contractual capacity and intention to create legal relations and so on apply to the principal. So the agent can act on behalf of, but the liability rests with the principal. So how do you appoint an agent? An agent might be a universal agent. That means appointed to act in unlimited ways, and there's no curb on his powers. He can be appointed as a general agent, which means he acts in a particular group of transactions. Like, for example, he could act in the banking, or he could act as a real estate agent or an estate agent. Or he could be an agent, a special agent, which means he's just appointed for one particular purpose. So normally an agency is created when that person enters into a contract between him and the principal. The agent doesn't have to have any capacity to contract on behalf of his principal. He must if this other contract between him and the principal is to be enforceable, have full contractual capacity. And contractual capacity means what? He must be 18 years and he has to have sound mind. So the agency relationship arises initially without any contractual agreement between agent and principal. As for example, with ratification, is a form of retrospective adoption for by the principal and the agent, and recognition of his powers to negotiate on the principal's behalf. So the main ways in which an agent may be appointed include, it can be done expressly, which means it can be written or oral. If the agent is to be authorized to make contracts under seal, his appointment must be by deed in the form known as a power of attorney. Second, it can be implied, and this applies as an extension of express appointment and covers acts which are either in the ordinary course of the agent's business, and similarly acts which become necessary for the efficient performance of an express agency. So that means express agency means this is one that could be in any form, could be written, or it can be oral, and it can be implied by the actual acts that the agent carries out. The other way and someone can be appointed as an agent is ratification. And this has been normally noted. It operates certain fairly strict conditions has to apply. The agent must have acted for a named principal. The principal must have contractual capacity both at the time of making the contract and at the time of ratification. The ratification must be of the whole contract and has to take place within a reasonable time, and the principal must ratify in full knowledge of all the material terms. So normally when you have a ratification in a company, it would go before the board and then they would ratify all of the acts of the agent. Of course, you can have an appointment of an agent by operation of law. And this arises without prior arrangement when a person is compelled in an emergency to act as an agent. And this normally arises when goods belonging to the principal are in the possession of the person driven to act as an agent. So it's normally done for emergencies. And the last one is by estoppel, which means holding out. If a principal makes some sort of representation to a third party to the effect that A has been appointed agent, the principal will be estopped from later denying the effect of such a representation. So if the third party, on the strength of the principal remarks, negotiate a contract with A, the agent, believing him to be an agent acting for the principal cannot later retract or deny his representation. Now, once you are an agent has certain authority. He can have actual authority, ostensible authority, usual authority. Actual authority is what has been expressly or impliedly authorized by the agent. Ostensible means apparent authority. This is the power of the agent to bind his principal by any act in the ordinary course of the agent's business. Since a third party is not in a position to know the exact terms of an agent's appointment, if the act would appear to be within the ostensible authority of this type of agency, the principal will be bound, even if he has specifically forbidden that very thing. So for there to be ostensible or apparent authority, there must be three main factors: a representation that the agent has authority, reliance on that representation, and an alteration of position by the person relying on the representation. Usual authority, and this is the authority possessed by an agent in consequence of his involvement with a certain trade or profession. So usual normally depends on the facts rather than the legal criteria. The relationship between principal and agent. The duties of the agent to the principal include the duty to carry out the terms of the agency, to account for all the money and property received for the principal, and to keep proper accounts. And of course, not to make a secret profit or take bribes. The rights of the agent against the principal is to be remunerated, that's paid, to be indemnified in case there's any liability, and to a lien on goods belonging to the principal in his possession when the principal owes the agent money. And lastly, to stop goods in transit for the same reason. An agent may negotiate a contract revealing from the first the fact that he is an agent and for whom he is acting. Alternatively, he may disclose the fact of agency but not name the principal. And in some cases, the fact of agency is concealed altogether, revealing the principal only when the contract is concluded. The consequences to a third party will depend on the fact of disclosure or lack of it. So disclose principal. If an agent indicates he's acting on behalf of a principal, whether he names him or not, the contract is between the principal and the third party. The agent will normally have no liability, but there are exceptions to the rule. If the agent expressly or impliedly assumes liability on the contract, then he's going to be liable. If he signs a written contract in his own name, he is liable. If by trade, usage, or custom, or on a bill of exchange. If he's actually contracting on his own behalf, if he signs a deed in his own name, and if he refuses to identify his principal. And in all those cases, he will be personally liable. When the act of agency is concealed until the last minute, the third party can hold the principal liable on the contract when he discovers his existence and identity. Or he can hold the agent personally liable, even though he now knows he was acting on behalf of another. It is always possible for an agent to be doing something unauthorized, even specifically forbidden, and shall be within his ostensible authority. In such a case, the principal will be bound and liable on contract to a third party. If the agent is outside both his actual and his ostensible authority, the principal will not be liable on the contract as such, but the agent will be liable to the third party for breach of warranty or of authority. In this case, even where the agent acted in good faith. So an agency can terminate where there's a mutual agreement to end it, or the agent renounces his appointment, or the principal revokes the agent's appointment. And all of these are conscious acts of the parties, voluntarily made, which end the contract of agency. So, any questions on agency? Because in a bank, you have agency in different forms. You can have someone who comes in with a power of attorney, either limited by the duration or limited in terms of scope, or you can have a company that actually signs the power of attorney mandate. That's the bank's form. Or you could have a list of authorized signatories based on different levels. And those different levels give them different authorities in terms of what they can and cannot do. So let's look at joint accounts. So a joint account is an account opened by two or more persons. And the operation of it is similar to a partnership. So when opening a joint account, you have to be clear whether both or either signature is acceptable for withdrawals. And it must be clearly stated that any overdraft facility arising from the operation of the account, the responsibility is for both joint account holders. Joint account holders normally are jointly and severally liable for any debt owed to the bank. And it must be clearly specified in the account opening documents or bank mandate. Joint and several liability gives the bank as creditor a right of action for repossession of any debt owed to it against the debtors individually, severally, or successively until the debt is paid in full. The bank is able to set off the credit balance of one joint account holder's account against the debit balance of another account until the same name, under the same name, or the joint account itself. The bank can also bring an action against the estate of the deceased joint account holder. Any questions there?
What do you mean by they can bring a suit against the joint account?
Okay, so if you have if you have a joint account, and then you have an individual account, the bank has the right to take funds from that joint account to pay off the debt that is owed.
And that's for the person who has passed.
Or you mean for the deceased?
Yeah.
They can also bring an action against the estate of the deceased person for joint account.
Right.
Yeah.
But isn't when it has and or there's two, and it's both or, no, sorry. Yeah. Correct. If it's an and account, they both side, right? So that person passes away. Both are liable. If it's an or account, it's only the person who is deceased. And no actions can be formed against the person, the other person on that particular account.
Right. So
Okay. That means in the or, once the debt is settled, whatever is on that account for the or goes to the partner that's living, correct?
correct.
And on the and account, that stays in his estate until probate.
Yes.
Okay, gotcha.
Any other questions?
He said if it's an account, there needs to be a probate if one person dies.
Okay, so it's okay. If one party to a joint account dies, the surviving party has the right of survivorship.
Right.
So that means that he or she is beneficially, absolutely beneficially entitled to all the monies on the account.
Right. Okay.
Now, there are instances where you have an and account and a family member can sue on behalf of that account to bring a lawsuit. If they want to prove that, yes, the account is an and account, but that the person was only added on that account for a particular purpose, and all the funds in the account were put on the account from the deceased only.
How do they prove that?
How do they prove it?
Yeah.
They prove it by witnesses. They prove it by witnesses coming forth saying that, okay, let me give you an example. I don't know the name of the case, but there are quite a few cases like this under trust law. So you have an elderly person, right? An elderly person, family members live abroad. And one day somewhere they see Mary. And they remember Mary from a long time ago. And Mary asks how they're doing, where they're living, how you making it and all that. I'll visit you. So Mary starts to visit this elderly person. Then the elderly person say, you look like you need help. I can come in, I can help you. So Mary moves in. And then the elderly person say, you know, I'm getting down. I may need you to pay the rent. I need you to pay my medical bills. I need you to buy groceries. I'm going to put you on my account,
Mhm.
right? And so they have this person on their account. Now, when that person dies, right? Mary then says that all of the money is hers because they have a joint account.
Mm,
The
okay.
family member then comes up and says, I have correspondence from my mommy or my aunt or my great aunt saying that they're only putting Mary on this account because no other family member was there, and that the purpose of it was for her to pay medical bills and grocery bills. That was it. It was never the intent of my grand aunt to give her all of the monies in her account.
Right.
So there have been cases like that are being tried in court.
Okay.
But you have to be able to bring evidence, right? And they were able to do that.
I have a question about power of attorney. Can you go back to that for me, please?
Go ahead.
In an instance where a lawyer walks into a bank and says, I have power of attorney over Waltino. Waltino, and he has a document, let's just say a negotiable item, a check in Waltino's name.
Mm-hmm.
And Waltino and the bank have no relationship. But he's the lawyer, and he has a document saying, I have a power of attorney over Waltino, but I need to negotiate this item on her behalf, and I can do it because I have a relationship with you, and she is my, I guess, client, or I have power of attorney over her. And Waltino is well and able. If she wanted a relationship with the bank, she could have one. I think it was an issue with a name change issue. She had gotten married or something like that and couldn't get the name change. So the document that he had was in the old name. And so the bank wouldn't negotiate it because it was not in the name that she currently carries. And so he, as her lawyer with power of attorney over her, walked into the bank and said, I can negotiate this item on her behalf because I have power of attorney over her. And of course, we stepped back because, we didn't have a relationship with her. The documentation was in her name. We didn't understand why, she couldn't get the legalities in such a way that she was able to do her own, her own banking or that sort. And to us, she was
Okay. Before you even go as far as that,
right.
What was the transaction he was trying to do on behalf of Waltine?
Deposit a check in Walt's name on an account with his personal account.
His personal account? Oh no.
Yeah, his
No.
personal account.
No, cannot. No. And if that check is cashed and those funds go on his account, then the bank can be sued.
Right.
No, cannot happen.
Okay.
No. If he was putting it in his company's account and holding it in escrow, that's different.
Okay.
But he cannot put that in his personal account. That's not possible.
Okay.
Only thing goes in his personal account is checks that are payable to him personally.
Right.
No.
Okay.
All that falls in the category of fraud.
Okay.
And see, the thing about it is that he may not know banking law principles. You see what I mean?
Well, of course, he's a lawyer, so he said that, and then they always say that they've always done it in the past, and I can't imagine why. But it was something that
not on his personal account. Not on his personal account.
No.
He could put it in his company's account in escrow. But he cannot put that in his
When you say
personal
escrow,
account.
what do you mean by that?
A law firm can open up an account where they can deposit clients' funds. But it's a company account or partnership account. Depends on how the firm is structured.
Okay.
And he will put clients' funds in there. And he has a duty to manage those clients' funds. He cannot use those for his personal business. because that's fraud. So say if you're dealing with an attorney and you're buying some real estate and they require a deposit. So you give him a check for the deposit. He can hold that check in his escrow account until he's ready to start to formalize the transaction. He can do that, but it has to be in his company's escrow account.
Right, and he wouldn't have to prove by documentation that he has power of attorney over the individual.
He wouldn't need power of attorney to do that.
No.
No. Mm-mm. For him to have a power of attorney for Waltine,
Right.
he needs a power of attorney document from Waltine to him in his personal capacity. And with that power of attorney, that gives him the right to deposit that check on Waltine's personal account, not his.
Right. Okay.
So like I was saying, when it comes to banking law, yes, banking law is based on contract law, but as you can see, banking law is like other areas of law. You have to go beyond contract law to know the rules of banking. And so if you've never studied the rules of banking, then only thing you just know is that there's a contract between you and the client, but you cannot deposit that check there. That does not follow banking rules. And always look, when you see someone say they have power of attorney, they need to have a document.
He did. He did. There was something to do with her mother's estate, and he was the executive of the estate. And so he had, and then there was a line that said he had power of attorney over this person, and we couldn't understand why the person was well enabled, and he had power of attorney over her. It just didn't make any sense.
Hold on. So he had one power of attorney, one document.
He had a legal document speaking to her mother's estate. The mother had passed away, and then he.
So why would he have power of attorney then of one of the beneficiaries?
Right. Like
No, that don't sound right.
She was appointed like the main beneficiary, and he said there actually was a line in the document saying that I so and so have a power of attorney over Waltine Hope, and it actually said that, and it was like, okay, that doesn't really mean anything.
So okay, and so this Waltine Hope is what? Senile? Sick?
No,
Nothing?
only because on the account with at Scotiabank, Waltine Hope is Waltine Archer at Scotiabank, but she actually carries the name Waltine Hope. And so because Scotiabank would negotiate the check that's in Waltine Hope, he's saying he got power of attorney over her, and so he's bringing the check to us to put on his account to negotiate on her behalf.
Now the next question comes to your mind is this: if this check is the name of Waltine Hope, why would that person at today's date write that in the name of Waltine Hope when that is not her name?
Yeah.
I hope you all call the police.
all her banking law skills supposed to come in then.
I tell you.
So that is not right. That is not right. Not right at all. No. Just the whole premise of that is not right.
Yeah.
Because if he's doing a transaction on her behalf based on her mother's estate, right?
Mhm.
Do you know how that works in terms of estate?
No.
Okay, so listen. Waltine mommy, Sarah, passed away, right?
Mhm.
She either wrote a will or she didn't write a will. Let's leave that part out. She left her assets to Waltine. Okay?
Mhm.
So let's just say in her will was written some time back before Waltine got married.
Right.
So it's in Waltine's maiden name. Okay?
Right.
When Waltine takes that will to an attorney to execute the probate, she then would say, this is my ID, my verification, my passport, my NIB card. Okay? Because she has to show proof that she's related to the deceased. Birth certificate. The lawyer then goes to the probate registry and completes the necessary forms to carry out the probate, which means that he then has to go and find out where the assets are that belong to Sarah. Once he's listed all of those and sent that to the probate registry, the court then reviews it and says, we will grant you a probate. When they give him that probate, that's when he goes now to collate all of those assets that now belong to Waltine,
Right.
right? If the documents that Waltine gave him is in her maiden name and not in her new name, she's at fault. Because the assets cannot pass. Because the names on her various accounts are in her new marriage title.
Right.
If they're in her maiden name, then there isn't a problem. But she
Right.
does not need a power of attorney if she has full mental capacity.
Agree.
So that's already a red flag right there.
Mm-hmm.
Why would she need a power of attorney in order for funds to be deposited in her account?
Mm-hmm.
Because all he has to do is go to the bank, show the probate, pass the ID, and a wire transfer can be done if it's at different banks.
Mm-hmm.
He doesn't need a check. So that's another red flag. One, why you need a power of attorney for someone who's fit as a fiddle.
Right.
Two, why is it in not in the current name? And three, why aren't we doing wire transfer?
Mm-hmm.
And then fourth, why is it going in your personal account? You're an attorney.
Yep.
Okay. So be aware of the attorney when you come again. Question everything that they do.
Yeah.
Yeah.
Mhm.
You see? No, that ain't right. No. Mm-mm. Mm-mm. No, 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 no. No. So for a joint account, the mandate can be terminated when the bank received notice of a dispute between the parties. And it's always good when there is a dispute to advise the bank. Because sometimes the other party goes and draw off all the funds.
Yeah.
So it's always good if there is a dispute to let the bank know. So that if the other party comes to draw off all the funds, they will make a phone call to you. Even though they have the right to draw off whatever they want, at least you are aware. So when all the parties give their written instructions to terminate the account, or when the bank has notice of the death, bankruptcy, or mental incapacity of one of the parties to the joint account. So I know right now the Thursday papers are very long, but you must read the Thursday paper.
Definitely.
You must. Now, the funny thing is now, they say there are 220 bodies in the morgue.
Wow.
How do you know if any of those are your clients? Because you could still have people around operating those persons' accounts.
The bank does that.
Yeah, I know. That's what it said in the paper. What would it said in the morgue?
Oh.
Mm-hmm. Okay, so partnerships. That's a business relationship with two or more owners. Normally it'd be accounting firms, law firms. And every partner is considered an agent to the partnership.
I have a question though, before you
Go
go
ahead.
on. Is it a bank thing where if someone passed away on an account, they were sole owner, and the next of kin comes and says, I think my family had some assets here. And the bank will say, okay, we can assist you with a certain amount for final expenses. Anything else outside of that, you have to bring me your probate.
Uh-huh.
Now, how did I get into banking law?
Okay, so let me see if I can put it to you simply. Okay, when you die, right?
Mhm.
When you die, in order for anyone to receive whatever assets you leave behind, whether it is cash, whether it is clothes, whether it's property, you have to go through probate.
Mhm.
Okay, that's called the probate registry. Now, when you die, the administration of your estates, which means the paying out of your assets, fall under what we call administration of estates legislation. So there's a whole set of legislation that deals with when you die, the type of application and the process to
Mhm.
transfer those assets from the deceased to the beneficiaries. And there is a section in there that speaks to when a person dies, how much money can be taken from their account to assist with burial expenses.
Okay.
And you cannot exceed that.
Okay.
And it says that the bank manager could ask for whatever documentation they require to satisfy themselves that is actually going to pay for funeral expenses. So that's why the check is always, or the wire transfer is done directly to the funeral home.
Right. Mhm.
Right.
Okay.
So, right. So say the person has 15,000 on their account and someone comes for 7,500. By law, they cannot have it.
Right.
The act stipulates how much they can have. The difference cannot go anywhere until they receive that probate from the probate registry.
Right.
That's how that works.
Should we even, in a duty of confidentiality, we shouldn't even be giving out any balances until?
No balances, no
Okay.
balances. No balances at all. If they want, if they say there's a funeral, so-and-so died, they bring you the death certificate. You would have already verified it. You'd have seen it either last week or week before last paper. So you know the person is dead. You verified it against that. You check the death certificate, the date of birth, and all that. So that is the person. You look on the bank account, you see they have 3,500. The law says they can have 2,500. You make the check payable to the funeral home for 2,500. Nothing else you can tell them.
Right.
Absolutely nothing. If they have a fixed deposit there, I cannot tell you anything.
Right.
Their lawyer, whoever's doing the probate of their estate, will then write to every bank, every credit union, every insurance company, using all the names of that person, all the aliases, to see if they have any bank account or any insurances.
Okay.
That's how it's done. So until they get the responses from all of those entities, unless that relative knows as a matter of fact that their mother only had account at Commonwealth Bank and at Scotia Bank, never went to the credit union, only have life insurance with Family Guardian, then that lawyer will have to write everywhere.
Okay. Wow.
Yeah. Yes. That's how it works. And if no one is appointed, let's say no will was done at all, then the law decides under the Inheritance Act who gets the money. That's why you should always write a will.
Yeah.
Because other than that, the law will decide who gets what. So if you die with a husband and no children, he gets all.
Right. Okay.
That's how that works. Any other questions? No one else had to deal with dead people, I see. Or crooked attorneys.
I stay away from them.
But they no, because they always give you the impression that they are smarter than you are, correct?
Yes, of course, you know.
Of course.
Very to try to be very intimidating.
Yes. But now you've been the banking law, you know better.
Yeah.
You don't doubt yourself. You
No.
just have to do it step by step.
Right.
What he's saying didn't make any sense.
No.
That don't make any sense at all. He could argue until the cows come home. That made no sense. None whatsoever. But if he could confuse you and you accept it, then yes.
Mhm.
Yes, you got to be very careful. So let's talk about partnerships. You don't have any issue with partnership accounts, right?
I'm sure they do.
So a partner's liability is joint liability for any debts and obligations of the partnership, and joint and several for any torts. Remember what torts are, right? As an action against a person.
Mhm.
Creditors can pursue partners individually, or they can do the partnership generally. Partners are liable for the actions of the other partners, where such actions were done on behalf of the partnership or in the partnership name, subject to certain exceptions. So notwithstanding the joint liability for debts and obligation by partners, banks normally require partners to be jointly and severally liable in opening partnership accounts in order to protect their interests. Proper customer due diligence is carried out on all partners, including verification of the partnership. The business of the partnership has to be legitimate, and a review of the financial standing and suitability to operate a partnership account. All that is a part of the due diligence process. If the partners are existing account holders, the usual due diligence requirements may be waived if the documents are valid. So let's go back to our last class. Remember what the QC was saying? What did the QC say? I showed you all the article. You remember? The lawyer from Freeport, what did he say? QC, what did it say? You all don't remember?
No,
QC
No.
lashes out on KYC constipation. You remember?
I don't remember.
Fred Smith.
Friends, that's the one who, when they were asking for the documents, they already turned in some, they didn't have the right to close the account.
No, that's Maurice Clinton.
Oh, okay.
That's Maurice. The one, but the other one, the second one we discussed was QC lashes out on KYC constipation. Remember, he was saying that he and Graham Thompson have an account at the bank, and the bank still asking them for KYC, that they are
Right.
existing account holders, right? That's what he
Right.
called KYC constipation. And he's saying that is not making any sense.
Because they already have all their documents in place for another account, but they're
Right.
trying to open up another account. But do you know that banks still do ask you to bring in documents, even though you already have an account? Because those accounts, say they were opening up these accounts, say they had these accounts for a year, 2 years, 3 years, some of the information might have changed. So the question is, can you bring some updated information?
Okay, now, all right, so now let's go back to the case which you was just talking about earlier, Maurice Clinton. What did the court say in the case of Maurice Clinton? Because he had the same issue, you know. He had all of his documents on file. They had asked for more updated documents. He provided some. What did the court say to him, to Scotia? What did the court say to Scotia?
They basically stated that they have most of his documents, so they couldn't close this account.
Exactly. So that's see, this is the thing when you talk about tick box. You have a tick box of documents, right? You have 15 items you need for an account, and you ticking it. And because you don't have the 15, then you're gonna say you're gonna close the account. The court is saying, is there sufficient documentation on file for the account to operate? What are the essential documents that the client needs to operate the account? That doesn't mean that you cannot keep requesting it, but you cannot close the account if you have sufficient information on file for the account to operate. So whatever document is missing, is that document really pertinent to the operation of the account? That's the question as a banker you have to ask yourself.
Mhm.
So let me give you a good example. Say if you have an account that has 6 signatories, right? You got the KYC for 5. Are you going to close that account? Or are you going to say, write to them and say, because I do not have the KYC documentation for Waltine, we will only accept documents that are signed by A, B, C, D, and E. That's it.
No,
That makes sense.
But that makes practical sense, operational sense.
Mhm.
And that's what the court is saying. You can't go by tick box.
But that's how they operate.
Yeah, but that's how they're operating, right?
They be so, yeah. It's so rigid with,
Yes, it's rigid,
requirements. Yeah.
right? And so that case demonstrates Maurice Clinton. That's why I was telling you all, read it again. Take your time and read it slowly, and you can see what the court is trying to say. Maurice said he sent in documents. Yes, he didn't send in all 15, but did you have sufficient in order for the account to operate? And then you close an account because an account had a 0 balance. You know, by law, he cannot operate a US dollar account unless he gets a US dollar check from a US client. So why are you closing the man's account? So when he gets a US check, what is he going to do with it?
Mhm.
he has to
can't
put it
deposit
in
in
the
his
US.
$3 account.
Yeah,
He can't deposit it.
no,
And you're closing his account, which was open under the permission of the exchange control. So you didn't even write to exchange control to say you are closing this man's account because he don't have any money in the account. Does that make sense?
No.
That don't make
So
no
the-
sense.
So did the banks take note of this ruling and make any adjustments?
Oh, they
or-
should. They should. They should, because if they don't, they're being caught again.
Or they could tell Maurice, take your business elsewhere.
But
But
Maurice probably did take his
though-
business elsewhere.
'Cause he's
He
trying to
probably
stay in
did.
trouble. Him and Fred is too much trouble.
No, but I mean, yes, I know he's
I'm
a
only
very
kidding.
contentious person. But the point is
Okay.
that his case to me was a very good case because the banks were getting away with this too often.
Yeah, it'd be a little ridiculous.
Right. Closing people accounts. All they hear is, oh, KYC. Oh, close it, close it, close it, close it.
Mhm.
But that case determined, you imagine all of those accounts they closed in the last 6 to 7 years of all of those persons had done class action suit against the banks.
Wow.
You could imagine what an uproar would have been in the banking community.
Mhm.
Because by right, the court said, no, you cannot do that. It's what's reasonable. You have to let people know. So let's just say you were in Maurice Clinton, a law firm. Let's say it was an individual account. You had your pension coming in, you had your NIB pension come. Let's say you have direct credits coming in and they close your account. What are you going to do? How are you going to operate? How?
That information is known though. That information is in your documentation. That the bank has the right to do that up with 0 balances. The one
Yes,
that-
but I agree. But you heard what the court said. If that is an account, right, where there are direct credits come in, you have to give that person reasonable notice to advise those parties that your account has been or will be closed on this date, and now you're opening an account at another facility. You can't just close it.
No, I think.
That's what reasonable means.
But I think in the instance, if information is made known to you from the beginning of how your account operates, you know that if there are no direct credits in the account in 1 year, it will go inactive. You know that if you do not do anything for this account for 7 years, it's going to go dormant and go to the central bank. So we give the customers the information they need to operate their account efficiently.
And what is the guideline? And what does the central bank guideline say to you as a bank?
Make sure the customer is aware.
And every year you have to call them.
Make attempts to call and bring them-
Yes.
yeah, update.
So it's also on you. So even though the client doesn't contact you, you have a duty to reach out and find that client. And remember what I said, because the bank is an institution with skilled and expert staff, it's always, everything is stacked up against the bank. Always. The bank has to prove that it did everything according to the letter. Everything. And most of the documents that a bank gives a client to sign is drafted by the bank itself. And the court will always construe against the maker of the documents. Again, because of their expertise.
Yeah.
So the court looks at, you have all the skills, you have all the money to do all of these things. But here you are now bombarding this poor little individual. So unless that individual did some fraud, some money laundering, some bribery somewhere, they will construe against the bank.
Okay.
Just always remember that. There's some certain key words you learn in banking law, and always put them in your mind, is what is reasonable. Are we being reasonable?
But we don't make the rules.
Huh?
The
I know you
directors
don't
come
make the
down.
rules. I know the rules come down from wherever they come from.
Yeah, they come down from Canada.
Yes, the rules come down, but when they are to be interpreted, they're interpreted according to what happens in the Bahamas.
Okay.
Remember that. If I can find that case
So
for
Ms.
you.
Archer, a question.
Yes, go ahead.
So if me as an entrepreneur, let's say I operate a restaurant, I could refuse the right to serve whomever I want. I don't care what it is. You may have, I don't care whatever reason, but I could say, you know, at this time, I'd really like you to access my premises. I don't even need to give you a reason why. I could do that. But you saying the bank cannot do that?
No.
Okay.
You mean as a person coming in to open an account?
Not open an account. Like basically like what you just said. The account is already open.
Uh-huh.
But
So that's the first thing. So the account is already open.
it
So
is
we already have
open.
a contract. We have a contract.
All right, so you answer my question. Never mind.
Right. You have a contract.
Okay.
Right. So once they are an existing customer, there is a contract. The bank has its duty and its rights, and so does the customer. The customer may not know offhand what their rights are or what their duties are, but you know what they are on both sides. And you have to respect it. And I think that's what the lawyers use, is the lawyer knows what their rights are and they know what your duty are. Any more questions?
She says, as a business entrepreneur, restaurant owner, she can refuse to serve who she wants.
Yeah, why not? What's stopping her? That's her business. I don't want to serve you. But she cannot do that in banking if he's an existing customer. Remember that he's in a restaurant. There's no contract between her and that person. But in banking, there is a contract.
That makes sense.
That's a different type of relationship.
No, well, I mean, I did a case of that before about the married gay couple. And the restaurant owner was found to be in breach. Because.
That was discrimination.
Yeah,
That's different.
okay.
Yeah, that's discrimination. That's against their constitutional rights.
So if you refuse to serve me in your restaurant, can I sue for?
On what grounds?
Sorry?
On what grounds?
Yeah, on what grounds is exactly what I'm asking. Why
You can use, you'll have to use something from the Constitution.
Mm.
The Constitution is your fundamental rights. based on sex, race, creed, those things, disability, your fundamental rights as a human being and a citizen of the Bahamas.
Okay.
Yeah.
So if the restaurant owner does not give me a reason as to why he doesn't want to serve me, I have no case?
Unless you know of something that everybody else doesn't know, that person, you've spoken to them before, saw them somewhere else and they didn't like you because you were gay,
Okay.
or they didn't like you because you were Jehovah's Witness.
Okay.
But you have to have a ground. And that ground is in Constitution. Your fundamental right. So those who haven't read the Constitution need to read it. So partnership accounts can be operated under joint and several liability. The credit balances on any personal accounts of the partners may be set off against the partnership debt. And joint and several liability is important to the bank so that it ranks equally with the partner's creditors when a partner dies or becomes bankrupt. When borrowing,
If the one partner has bills, a loan that's charged off, the partnership can pay for it?
yes,
Okay.
No, I don't think so.
why not?
But wouldn't they have to be bills for the partnership, like business
No,
related debt?
that's why it's joint and several. It's normally joint and several.
Okay, okay,
Joint and several.
okay.
So
Wow.
under the law, a bank customarily require the authority of all of the partners for non-trading partnerships. Since there is an implied authority of common law to borrow. Under the law of partnership, the retirement, removal, or death of a partner dissolves the partnership. If a partner retires and the partnership wishes to continue under the existing name, the bank ordinarily requires that a new mandate be signed by the remaining partners with the relevant terms and conditions. If the account is in credit, the account may continue to operate provided that the remaining partners consent to the checks written by the retiring partner. To avoid the rule in Clayton's case operating to its detriment, the bank should ensure that the partnership account is closed on the resignation of a partner and open a new account with the remaining partners. And likewise, the same principles apply where a partner dies and the partnership is effectively dissolved. If the account is in credit, the partners must sign a new mandate to continue the account to wind up the partnership. If the account is overdrawn, the bank must close the account to preserve the liability of the deceased partner and prevent the rule in Clayton's case operating to its detriment. Company's account. Everybody knows a company is a legal entity. Its identity, liability, and obligations are separate from the shareholders. And that was established in the case of Solomon versus Solomon. So the liability of a company is limited and the shareholders are liable to the amount to which they have invested in the company. A company in the Bahamas can be established under the Companies Act 1992 or the IBC Act 2000. And a company is formed upon the reservation of a name, the statutory filing of its memo and arts, and the issuance of a certificate of incorporation by the Registrar General. A company may be limited by shares and guarantee, by guarantee only. And once you open a corporate account, the bank requires certified copies of the following documents. In addition to the due diligence information on the shareholders, the principals, the directors, and officers of the company. So what are the documents needed for a company to open an account? You need the copy of the certificate of incorporation that's issued by the registrar. And the certificate of incorporation shows when the company came into effect. The memo and arts, And that just gives you the fundamental provisions of the company's constitution, gives you the name, type of company, registered office, its objects, and the classes of shares and the subscriber's name. The articles more or less tell you how the company is to be run. So it includes issuance, things on issuance and transfer of shares, management, appointment, resignation of directors, who are signing authority, indemnification, and winding up procedures. You normally will get a certified copy of the register of shareholders and the register of officers and directors. Depends on how long the company was incorporated or in operation. You would ask for a certificate of good standing from the Registrar General's Department. Normally you would ask for a copy of a banking resolution. That could be in two forms. It can be a resolution done by the board and a secretarial certificate confirming that the board had agreed to opening of an account, or some banks have their own standard form for the bank to, for the company to actually fill out to say that they're establishing an account. Imprint of the company seal. Sometimes the articles actually state that the imprint of the seal has to be provided. As you know, the recent amendments to the Companies Act now requires that a company does not have must have a seal, so they can actually prepare deeds without the imprint of the seal. And of course, you can also ask for a copy of the list of authorized signatories. Now, the next type of account you could have is unincorporated clubs and societies. And these have no separate legal existence from its members. They're normally conducted by an elected or appointed committee or executive officers in agreement with the bylaws. A copy of the organization's bylaws are normally required to verify the nature of the organization and the extent of the powers of its officers to operate the account. They normally have a resolution passed in general meeting. And normally, with regard to borrowing, the bank normally requires some personal guarantee or agreement from the officers of the organization or a defined person before advancing any monies, as the organization is not a legal entity. Now, bank statements. The bank has a duty to maintain an accurate record of a customer's transactions. However, a customer has no obligation under common law to check the accuracy of their statements or report inaccuracy when they receive them and may challenge their accuracy at a later date. Anyone read the case of Taihing? That's the leading case. No? What happened to my eager beavers? If a customer account is overcredited, the excess credit must be refunded by the customer immediately, as the customer is deemed a constructive trustee under law of the excess funds which are owed to the bank. Now, a customer may challenge a claim for the refund of excess credit to their account by proving that the following conditions existed. And these were based on the case of United Overseas Bank versus Giovanni. 1, the bank misrepresented the state of the account to the customer. 2, the misrepresentation was sufficient to mislead the customer. And 3, as a result of the misrepresentation, the customer has changed his circumstances to the extent that any repayment of the excess credit would be unfair or detrimental to the customer. You agree with that?
Wow. No.
What do you mean, no?
Well, I guess if the bank misrepresented, yeah, okay, I agree.
Okay, so
Yeah.
in the case of Skyring versus Greenwood and Cox, in that case, the paymaster of a military corp credited an officer's account with money to which he was not entitled. The erroneous credit stretched over a period of 5 years, and the officer, who was unaware of the mistake, drew the money out regularly. When the paymaster discovered the error, he continued to pay the officer's wages, failing to inform him of the need to rectify the position. When the officer died, the paymaster purported to set off the amount so overpaid against the balance standing to the credit of the officer's account. The estate's action disputing the right of the paymaster to effect such a write-off was successful. It was held that the erroneous entries constituted representations to the effect that the amounts involved had been received for the officer's credit. As the officer had changed his position in reliance on the statements by spending more money than he would have otherwise done, the paymaster lost his right to reclaim the amounts credited. Now you see what that case says, right?
Yeah, yeah.
They overpaid him for 5 years.
5 years, yeah, that's ridiculous.
And he adjusted his living according to that. So now they found a mistake. They want to take it from the funds that is left after his death. And the court said no. So
Yeah, I
it
agree
doesn't
with that.
matter whether he's dead or not. There were funds standing to the credit of his account. So in the case of Holland versus Manchester and Liverpool District Banking, the customer's passbook showed a credit balance of £70 instead of the true amount of £60. In a reliance on this entry, the customer drew a check for £67, which was dishonored when presented. The customer's action in breach of contract succeeded. Justice Lord Alveston held that the bank was entitled to debit the customer's account with the amount erroneously credited, but did not have the right to dishonor the checks drawn for sums within the balance conveyed to the customer until, at any rate, they gave him some notice. You see how this notice is so important?
Yes.
So his account statement was incorrect, but at the time in which he read it, the amount that he wrote the check for was within the amount that is stated on their piece of paper.
Right.
And so they said that they didn't have the right to dishonor his check because that's the balance that you stated that the man had. So it says here that the bank is always entitled to rectify the error within a reasonable time.
Right.
You see that notice in reasonable time keep coming back and forth again. Furthermore, the customer can plead the estoppel in question only if he was misled or had reason to be misled by the erroneous balance. And this principle was established in the case of British and North European Bank versus Zalstein, where the customer did not discover the wrong credit entry made in his favor until it had been reversed. It was accordingly held that he could not dispute the respective debit entries. At present, the principle is best illustrated by United Overseas Bank versus Girari. In that case, the bank erroneously credited its customer's account twice with the amount of a single remittance. The amount involved was substantial, and the customer was not expecting any payment additional to the one genuinely received for the credit of his account. Despite this, he drew on the balance accrued as a result of this windfall, and thereafter disputed the bank's right to reverse the undue credit entry. So the bank, he was expecting, let's say he was expecting $5,000, but the bank sent 2 entries of $5,000.
Oh, that's good.
Okay, so despite this, he drew on the balance accrued as a result of this windfall, and thereafter disputed the bank's right to reverse the undue credit entry. It was held that the customer ought to have known that the unduly high balance shown in his account was inaccurate. He was not expecting any additional payment of a substantial amount to the credit of his account, and he was not entitled to shut his eyes to facts staring him in his face. The bank is entitled to rectify an error in the account records if the error is induced by the customer.
Finally, the bank wins. My Lord.
Huh?
Finally, the bank wins.
Yes. But see, he had to prove that.
And Ms. Archer, the bank was bound to, I mean, the bank had to let him know of the error, right? Before they reversed the funds.
Yeah,
Okay. And what does the court consider reasonable time?
nah, that comes to the tricky part.
Okay.
Reasonable notice depends on when you knew.
Mm.
So if you knew today, what is reasonable? Tomorrow, eh?
Yeah, or at least, yeah, within a week.
Yeah, because you're dealing with money. You're dealing with money. People are active when it comes to money. So let me tell you all the facts of the case of Tai Hing, which is the leading case on this bank statements. Over a number of years, a clerk who had, let me see if I can find a line. Over a number of years, a clerk who had the custody of his employer's checkbooks forged the general manager's signature on a substantial number of checks, all of which were paid by the three banks with which the firm had its current accounts. As the firm did not retain any regular audits, the clerk's defalcation remained undetected for a long time. Sound like COB. Finding that the firm's system,
That was a big day.
finding that the firm's system of internal accounts was deficient and had facilitated the fraud, Judge Mantel gave judgment for the bank. His decision was affirmed by the Hong Kong Court of Appeal, which held that the firm had been in breach of a duty of care owed to the bank, both in contract and tort. The Privy Council reversed the Hong Kong Court of Appeal. As regards the claim in contract, Lord Scarman held that in the absence of express agreement to the contrary, the risk of wrongful payments was borne by each of the three banks. Banks offer a service, which is to honor their customers' checks when drawn upon an account in credit or within an agreed overdraft limit. If they pay out upon checks which are not the customers, they are acting outside their mandate and cannot plead his authority in justification of their debit to his account. The risk is a risk of service, which it is their business to offer.
Wow.
His lordship emphasized that the customer's duty to refrain from facilitating a fraud applied only as regards to drawing of his checks. The customer was not under a wider duty to adhere to business practices aimed at combating the perpetration of fraud, or a narrower duty to check periodic statements. Referring to the claim in tort, Lord Scarman said, their lordships do not believe that there is anything to the advantage of the law's development in searching for a liability in tort where the parties are in a contractual relationship. This is particularly so in commercial relationships. So you heard that? Always construe against the bank. So if an account is wrongly debited, the amount debited must be returned to the customer's account immediately, as the bank has no mandate to debit the customer's account in this instance. Where the bank has incorrectly debited an account and returns a customer's check as unpaid due to insufficient funds, the bank is liable for wrongful dishonor of a check. It may also be liable for breach of contract and defamation of character. In the event that a bank wrongly debits an account and has subsequently returns a check unpaid, it is advised to take the following steps. 1, refund the incorrect debit. If instructed by the customer, contact the payee and make payment. Apologize for the wrongful dishonor and explain that it was due to the bank's error and not the customer's error, omission, or deliberate act. A letter of apology must be sent to the customer explaining the bank's error and remedial action. Bank's credit references and opinion. A bank may receive inquiries from another financial institution to confirm or provide information on the credit worthiness of a customer. The bank must obtain the express consent of the customer, which is usually contained in one of the paragraphs of the account opening documentation mandate. The bank must be mindful of its duty of confidentiality and any relevant exceptions to that duty, and allow it to answer third-party inquiries and provide bankers' opinion and credit references on behalf of its customers. It must take into account two possible liabilities when you're providing banker's opinion. One, the liability to the customer for breach of contract if it provides a banker's opinion without the express consent of the customer or provides customer information beyond the scope of the inquiry. And two, liable if the banker's opinion is considered defamatory. Two, liability to the inquirer for negligent misstatement without a suitable disclaimer within the banker's opinion to limit liability. So that's why when you normally ask for reference, it's only just 2 sentences on a roundabout figure because of the liability involved. Now, my eager beavers. I see Yuri is on the line. He's very quiet. Hello, Yuri.
Hey,
You
good
can't
night.
still be in the bank.
Ah,
Now,
No.
now, you know, I normally try to keep to my agreement from the first class. So do y'all want to start? Let's go Makushla tonight, or you want to leave that to Wednesday in class?
Wednesday.
I hear that quick. I hear that quick from Walty. Denise, Atia, what you say?
I say Wednesday.
Okay, so everybody would have a chance to read it, right?
Yeah, I agree.
Okay, so this should actually culminate with everything that we have done so far.
Right, because those things kind of related with
Yes,
the,
exactly. So this is about her, and well, of course, you should be able to present this to us, eh?
I read it briefly before, but other extensive cases have been given to
Okay.
us. I heard
Yeah.
about the case.
You heard about the case. Now I want you to actually read it from the judge, and we're gonna tie it into our banking law, what we've learned so far.
Okay.
Yeah. You had a chance to read the Maurice Clinton one?
No, I haven't.
Okay, read that one too in case you have any questions next class. Your colleagues will be able to answer all of them.
Okay, that's cool.
Don't mind them being silent. We read that. We read that. So we'll do Makushla Pinda, and there's another case I need to find you all with a joint account. I can't remember where that is. There's another Bahamian case. I have to look for that one too for Wednesday. And then we'll do checks. And when we do the chapter on checks, I know that the chapter looks very long, but a lot of it is no longer relevant as we more or less phase out checks to move more into the electronic side of banking. So I just highlight what's important under the chapter on the checks. Okay? All
Yeah.
right. So once I get this other case, I'm going to email it to everybody. Okay?
Okay.
So be that case along with Makushla, and then we'll do the highlights of the chapter on checks. But
Okay.
more focus will be on the same thing when you operate account and reasonable notice. It will be more to focus in terms of moving towards the exam, because that's where a lot of the issues are, not just here in the Bahamas, but internationally. Okay, on notice. As we move away from checks and we begin to use more electronic devices.
Well, they're saying most persons don't accept checks no more.
Exactly, that's why I'm saying I'm just gonna highlight just the important parts of it in terms of like companies that have checks and fraud. I'll do the essential elements of it, what it means, a check means legally, but then we'll just look at the fraudulent part of it because that's
Okay.
not, yeah, that's not what people use today. And then we'll focus on the cards electronically, okay?
Okay. Check
All
card
right.
still open, the company.
No,
I don't know.
I think they closed.
You mean check card?
Yeah,
I don't even hear people talk about that anymore.
me either.
It was a couple of years ago.
Oh, they closed.
Yes,
Oh,
ma'am.
they closed? Oh,
Yeah.
well, thanks for telling. Yeah, because everybody's, but I noticed, you know what I noticed today? I went to Tire Flex. required. And I don't know why these people are so behind time. Because no required if you have a chip card. So why do they keep asking for IDs if you have a chip card?
And signatures.
A signature. That makes no sense.
Yeah,
So
some
even-
places do ask.
But that,
No, the
but go ahead.
The pen should suffice as identity.
Why you need it?
No, you don't need anything else with the pen. The pen should suffice as identity.
Exactly. But they're
Cardholder should-
asking for it. They're even putting signs up. I think banks need to let their corporate clients know that they are hindering business, because that makes no sense. So that means if I run up with just a card, I can't do any transaction because I don't have an ID with me.
Do you know the banks have difficulty with that as well? Because we just moved over to chip maybe about 2 years ago or so. And so
Uh-huh.
we came from an ID-based background. And so moving to chip was difficult and still is for some, because we're so used to asking for this ID. Even
No,
though
you gotta
policy
change. You gotta
policy
change.
releases us, yes, but
Yeah, you have to
still in
change.
your mindset says, oh, just let me double check, because Waltine could be a man or a woman. Who knows? So is it a double
Yeah, but
check?
but the thing about it is this: if Waltine came to you now and Waltine said, "I didn't make that," then how did that person get your chip? How did they get your pin?
Right.
How did they get your pin? That's the thing.
They kidnapped
Ask
her.
McCushla Pender then.
Okay, well then we're gonna read McCushla Penda, and you can answer that question for me on Wednesday. You can answer that question for me on Wednesday. Let's see. Let me see how you answer that.
What's that?
But I gotta find this case for you all on the joint account. I gotta find that. I did it before. I did it before with an earlier banking class. I gotta look at my notes. I can get the name and I'll send it to you also. Those two we will discuss. Makushla and that account. And then we'll just do the highlights of checks when it's a corporate client and there's fraud.
Okay.
Yeah, that's what we'll do on Wednesday.
Exam postponing.
Say that again?
When is the exam for the rest of us?
What you mean, midterm?
Yes.
And I told you all to contact Miss Dean and do it this week, but not on my days.
She said
Oh.
Thursday.
Okay,
Where?
Thursday. you'll do it.
Thursday.
Okay, but Thursday it is then.
Thursday, okay.
Hmm.
Thank
Yeah.
God.
Yeah, it's not hard.
No?
So
No, it's
you
not.
say,
We went
Anybody?
over it already. It's not hard.
Anybody want to share?
I serious.
Just add my question. You need to start worrying when it's time for the final exam, not now.
Oh my God.
Oh, Jesus.
What
Are
happened?
your finals are
Aisha.
inclusive of all the chapters or just the chapters from the midterm on?
From midterm on.
Very good.
my
How much
God.
percent
Remember
is
now. Well, hold on
midterm?
now. Hold on. Stop. Remember now. Everything after midterm, right? Which was what we did last week on AML, tonight on different types of accounts. On Wednesday, we'll look a little bit at checks, then we'll look at ATM cards and all of that. Even though those areas are on those specific topics, remember what I said to you. Because this is a contractual relationship, the rights and the duties follow in this section. There wouldn't be a question as, what are the bank's rights and duties? That's a midterm question. You're supposed to know when you read a scenario, whether or not the bank has breached one of his duties or whether the customer has breached their duties.
Okay,
Yeah, that's how it is.
okay.
So it won't be specifically on that, but you're gonna pull out, oh, this is a duty. You're gonna say what happened, it was happening in the scenario, but the focus will be on something, one of the topics that we would have covered in the second half.
Okay.
Okay, so it won't be that difficult. The hardest thing for you to do is probably to be remembering the cases. But I normally tell you which case. I'll tell you which cases I'm looking for.
Okay.
Yes.
Ah, boy.
Miss
What happened
Asha.
again? Yes. Yes.
How much percent is midterm?
30, I think.
the
30?
difference what I
Yeah.
needed to get a B.
10% is participation and 60% is the final.
Okay.
Yes. So that means you must pass both.
Yeah, we figured that one out.
You have to pass both. Yes. Oh, yes. I offered you all a research paper. You refused.
Sorry, we have a research paper?
Yes, I offered that.
No, I didn't want, no, we good. We good.
Well, okay, fine.
What will your research papers be like?
Research for the final?
No,
That's
that
what
was
you
the
said?
midterm. What do you
Oh,
mean?
my
What would
Lord.
have been? One could have been on the impact of electronic banking in the Bahamas, or one could have been on like looking at the impact of moving from brick and mortar banks to more these little kiosks, things like that, research questions. And you look at other jurisdictions to see how they would have transitioned from where we are now to where they are. Moving from that full bank to just a kiosk.
So we could have
Discuss
get that
the-
instead of sitting an exam?
No, I'm good.
No, you could get that in lieu of so many questions in the exam.
Oh,
Yeah.
okay.
I got
Any
No, a lot of
makeup
students take that option.
Yeah.
Some of them take that option.
So
And
any
sometimes I do it as a 20 points, sometimes I do it as a 30 point, depends.
any homeworks was given out?
No,
Okay.
no. Only homework you have now is question. Let me look for this case now so I can send it to you all. Okay. I'll use the link from Miguel. What he sent with the thing with the invite for the day. I'll do a reply all on that and attach the next case. Okay.
Okay.
All right. So be prepared, and I'll see you all bright and early on Wednesday.
In person.
In person, yes. All right.
Bye.
All right,
Okay,
good
have a
night.
good
Luke.
evening.
Okay, thank
Likewise.
you.
Okay, bye.
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 Okay.